courtroom was smaller than I remembered. Or maybe I just felt bigger the last time I'd stood in one, 40 years ago, when I was still the kind of man who pressed his shirts the night before and shined his shoes without being asked. That morning, I'd driven to the Tarrant County Courthouse in my 2009 Civic, the one with the cracked passenger mirror, wearing a gray suit I'd bought at a Goodwill on Camp Bowie for $14. The jacket was a half size too big. The pants had a small bleach spot near the left knee that I'd tried to cover with a Sharpie the night before. My wife's attorney noticed immediately. He was the kind of man who wore cufflinks on a Tuesday. He glanced at me the way you glance at something tracked in on the bottom of a shoe, then leaned over and whispered something to my wife that made her press her lips together to hold back a smile. She didn't try very hard. She'd been sitting at the plaintiff's table with her back straight and her hair freshly done, wearing a cream blazer that probably cost more than my car. She looked over at me once, just once, and the smile broke through anyway. Not cruel, exactly. More like satisfied. Like a woman who had already won and was just waiting for everyone else to catch up. I looked down at my hands on the table and said nothing. Her attorney stood up and addressed the judge. He talked about my financial situation at some length. He mentioned that I had voluntarily left a position with Crawford and Lowe Engineering 2 years prior, that I had been living in a rented room in Haltom City since our separation, that I had no significant assets, no retirement account worth mentioning, and that I had declined to hire private legal representation. He used the word decline the way people say it when they mean couldn't afford. He said my wife was not requesting alimony, which he framed as generosity. He said she was requesting full ownership of the house in Weatherford, both vehicles, the joint brokerage account, and primary custody of our granddaughter, Lily, who had been living with us for the past 3 years while our daughter sorted out her own situation. He said all of this smoothly, without looking at me once. The judge, a woman in her late 50s with reading glasses on a beaded chain, glanced at me over the rims. "Mr. Webb," she said, "are you representing yourself today?" "I have a court-appointed attorney, Your Honor," I said. "He'll be here in about 10 minutes. There was a matter in Judge Calloway's court that ran over." Her attorney smiled at his notepad. I had been married to my wife for 31 years. I want to be careful about how I tell this part, because it would be easy to paint her as a villain from the beginning, and that wouldn't be true. For most of those 31 years, she was my partner in every real sense of the word. We built a life together out of nothing particularly special, a starter house in Fort Worth, 2 used cars, a daughter we raised mostly right, Sunday dinners with her mother every week until her mother passed. I was a civil engineer for the county for 12 years, then moved to private infrastructure consulting. She ran the administrative side of a small commercial real estate firm downtown. We weren't wealthy, but we were comfortable. We were fine. The change was gradual. That's the thing no one tells you about a marriage ending. It rarely happens all at once. It happens in small surrenders over months and years, in silences that get longer, in weekends that drift apart, in the way a person stops telling you small things and eventually stops telling you anything. Her firm merged with a larger outfit called Palladian Property Group about 4 years ago. The man who ran Palladian was named Donovan Hess. He was 53, divorced twice, and had the kind of confidence that comes from never having been wrong about money. He drove a black Range Rover and had a box at the Rangers games and knew which restaurants to get a table at without a reservation. My wife started working late, then started working weekends, then started coming home from client dinners at 11 o'clock at night smelling like a wine bar. I asked her about it once, directly. She told me I was insecure. She told me I was threatened by her success. She told me that not everything was about me, and that she was finally doing something meaningful with her career, and that she needed a partner who could support that, not undermine it. I apologized. I actually apologized. That's the part that still sits with me on quiet mornings. I found out for certain in November, about 2.5 years ago. I won't describe it in detail because it doesn't matter anymore, and because my granddaughter sometimes uses my laptop and I don't need her reading this. What I will say is that what I found was not ambiguous. There was no room for a reasonable explanation. I sat in our kitchen for about 2 hours after, just sitting. Not crying. Just sitting. The way you sit when something you thought was permanent turns out not to have been. She came home around 10 that night. I had the evidence on the table. She looked at it, looked at me, and said, "That was it. No apology. No breakdown. Just a statement of fact, delivered like a weather report." She filed for divorce 3 weeks later. What followed was the worst 18 months of my life, and I have had some genuinely difficult stretches. Her attorney moved fast. She had already, I later learned, transferred the bulk of our joint savings into a personal account 2 months before filing. By the time the divorce proceedings began in earnest, the joint account had $1,100 in it. The house was in both our names, but she had been paying the mortgage from that personal account since the transfer, which her attorney argued gave her primary financial claim. She had documentation for everything. It had been planned. I moved into a room I rented from an old colleague in Haltom City. I drove the Civic because she had taken the other car, a 2021 Camry, the week I moved out. I kept my tools in the trunk levels, transit rod, old field notebooks because I couldn't afford a storage unit and because, honestly, keeping them close made me feel like myself. Lily stayed with me. That was the one thing I held on to. My daughter had been dealing with her own circumstances, a bad situation in Dallas that took time to untangle, and Lily, who was 8 when all this started, had been in our care since she was 5. She knew my wife as her grandmother, obviously, but she knew me as the person who made her breakfast and drove her to school and checked her homework and read to her at night. When I moved to Haltom City, she moved with me. My colleague and his wife were kind about it. They gave us both the upstairs rooms. My wife's attorney argued, in the custody portion, that I was financially unstable and therefore not the appropriate primary guardian. He submitted my rental arrangement as evidence of instability. He submitted my voluntary departure from Crawford and Lowe as evidence of poor judgment. He suggested, without quite saying it, that a man who couldn't hold a job was not the kind of influence a child needed. What he didn't know, what nobody in that courtroom knew except me and 2 federal agents and a prosecutor in the Northern District of Texas, was why I had left Crawford and Lowe. I need to go back about 2 years for this part. 6 months after I moved to Haltom City, I was doing contract survey work for a civil firm in Arlington. Small jobs, enough to keep the lights on. One afternoon, I got a call from a woman who identified herself as a special agent with the IRS Criminal Investigation Division. She said she'd gotten my name from a former colleague. She asked if I would be willing to meet. I almost said no. I was tired. I was 62 years old, sleeping in a borrowed room, eating sandwiches I made at midnight. I did not feel like a man with anything useful to offer the federal government, but something made me say yes, and I drove to a coffee shop off I-30 and sat across from an agent named Reyes and her partner, and they told me what they had. Donovan Hess had been running a commercial real estate scheme for approximately 7 years. The structure was complicated, but the core of it was straightforward. He was inflating property valuations on transactions involving certain clients, skimming the difference through a network of shell LLCs, and using commercial real estate purchases to move money from at least 2 sources that the agency was still characterizing carefully. The numbers were significant. Not hundreds of millions. The scheme wasn't that large, but large enough that the federal interest was genuine and the exposure for anyone connected to it was severe. Agent Reyes asked me if I had ever been involved in any appraisal or survey work that touched Palladian property transactions. I had. Twice, both times for what I thought were routine engagements contracted through Crawford and Lowe. I had flagged some irregularities in the valuations to my project manager at the time and been told it was outside the scope of my work. I had let it go because I had bills to pay and a marriage I was still trying to save, and I told myself someone else would catch it. Agent Reyes looked at me for a long moment. Then she slid a folder across the table and said, "We'd like your help. I won't describe the next 20 months in detail because some of it is still under seal and some of it I simply don't have the right to talk about publicly. What I can say is that I became a cooperating witness for the Northern District of Texas. I provided documentation, testimony, and access to technical records. I attended meetings I won't describe in settings I won't name. I resigned from Crawford and Lowe because my continued presence there created a conflict with the investigation, and because the firm had its own exposure that I couldn't navigate while working there. The attorney assigned to manage my cooperation was a federal public defender who also, as a courtesy, agreed to represent me in my divorce proceeding given the unusual circumstances. His name was Gerald. He was 34 years old, drove a 10-year-old Subaru, and was the most prepared attorney I have ever watched work. He called me the night before the hearing and asked me 3 questions and told me to get some sleep. He arrived in the courtroom 11 minutes after the hearing started, apologized briefly to the judge, set his bag down, and opened his laptop without ceremony. Her attorney had just finished his financial summary. He had been thorough. He had painted a picture of a 63-year-old man who had walked away from a stable career, accumulated no assets, was living in a rented room, and was asking the court to award him custody of a minor child and a share of marital assets he had failed to protect. It was effective. I had watched the judge's expression as he spoke, and I could see the outline of a conclusion forming. When her attorney finished, the judge looked at Gerald. "Counselor, does your client have a response to the characterization of his financial situation?" Gerald stood up. "Your Honor, before we address finances, I'd like to enter into the record a letter from the United States Attorney's Office for the Northern District of Texas, dated last Thursday." He walked to the clerk and handed over a sealed envelope, "and I'd ask the court to review it before we proceed further." Her attorney frowned. "What is this?" "It's a letter," Gerald said pleasantly. The judge opened the envelope. She read it. She read it a second time. Her clerk, a young man who had been typing steadily throughout the hearing, stopped typing. The judge looked up at me over her reading glasses, and her expression was not the expression of someone watching a man in a too-big suit. It was a different expression entirely. "Mr. Webb," she said slowly. "Your full legal name for the record, please." "Marcus Allen Webb," I said. "I've also been operating under the cooperating witness designation, case reference 4417TX, for the past 20 months. The room was quiet. My wife had been watching this exchange with the particular alertness of someone who doesn't yet understand what's happening but knows something has shifted. She turned to her attorney. He was already leaning close to his associate, his hand partially covering his mouth. The judge set the letter down flat on her desk. "I'm going to need a brief recess," she said. She was gone for 14 minutes. During that time, my wife's attorney made 2 phone calls from the hallway, speaking quietly and quickly. My wife sat with her hands in her lap, very still, looking at nothing in particular. She didn't look at me. Gerald reviewed his notes calmly. I looked out the window at the parking lot and thought about Lily, who was at school right then, working on a book report about the Oregon Trail that we had been researching together on the weekends. When the judge returned, she was accompanied by 2 men I had not seen enter the building. They were wearing suits and carrying credentials. One of them spoke briefly to the judge in a low voice before taking a position near the back of the courtroom. The judge looked at my wife's attorney. "Counsel, I need to advise you that this proceeding is being formally paused pursuant to coordination with the U.S. Attorney's Office. Your client should be aware," she paused, chose her words, "your client should be aware that certain financial records submitted as evidence in this proceeding have been flagged in connection with a separate federal matter." My wife's attorney stood up. "Your Honor, I object to any." "You can object in writing," the judge said. She wasn't unkind, but she was final. "What I can tell you right now is that the brokerage account documentation your client submitted, the transfer records, and the Palladian Property Group transactions referenced in the asset disclosure are all now subject to a federal hold." She removed her glasses. "Mrs. Webb, I strongly advise you to consult with a criminal defense attorney before this proceeding continues." My wife turned and looked at me for the first time that morning. I don't know what she expected to see. Satisfaction, maybe. Some version of triumph. I've thought about it since, and I'm still not sure what was on my face. What I felt was not triumph. It was something more tired than that. It was the feeling of a very long thing finally being over. She looked away. What came out over the following weeks and months, in the public portions of the federal case, was this. Donovan Hess had been operating his scheme for 9 years, not 7. The total financial exposure, when fully calculated, was approximately $41 million across a network of transactions in 5 states. My wife had not initiated the fraud, but she had been aware of elements of it for at least 2 years and had received benefits, a personal investment account opened in her name, funded through one of Hess's LLCs that the federal government characterized as material participation. She was not indicted. I want to be clear about that, because accuracy matters to me more than drama. The prosecutor determined she was a peripheral participant rather than a principal actor, and her attorney negotiated a cooperation agreement. But the financial assets tied to those transactions, including the personal account she had funded from our joint savings, were frozen pending the federal proceeding. The Weatherford house, which had been partially purchased with funds that could be traced to the tainted account, became the subject of a separate civil forfeiture review. In plain terms, everything she had taken and planned to keep became unavailable to her. The divorce proceeding resumed 4 months later. It was a much shorter hearing. The asset landscape had changed considerably. Gerald had done thorough work in the interim, documenting my cooperation agreement, its timeline, and the explicit reasons for my departure from Crawford and Lowe. The judge received a formal letter from the U.S. attorney confirming that my actions had been consistent with law enforcement cooperation and that I had received no financial compensation beyond protected status. I was awarded primary custody of Lily. The judge found that continuity of care, established routines, and the existing parent-like bond were the determinative factors. The recommendation from Lily's school counselor, submitted without my asking, described her as a stable, well-adjusted child with a strong attachment to her grandfather. It was the best thing I have ever read. The house in Weatherford was eventually released from the forfeiture review and sold. My share of the proceeds, combined with the recovery of the joint account funds that predated the tainted transfers, gave me enough to put a down payment on a small house in Oslo, on a quiet street with a pecan tree in the backyard that drops more than any 2 people can use in a season. Lily calls it the nut tree. She has a strong opinion that pecans belong in pie and nowhere else. She's 11 now. She is sharp and funny and occasionally stubborn in ways that remind me of myself at that age, which I find both challenging and quietly gratifying. She does well in school. She has a best friend named Olivia, who comes over most weekends and has apparently decided our house is her second home, which I take as a compliment. I make them both breakfast on Saturday mornings, the same breakfast I made for Lily's mother 20 years ago. Scrambled eggs, wheat toast, orange juice in the good glasses even when it's just a regular day. I still have the gray suit. I haven't worn it since the hearing. I keep it in the back of the closet, not as a trophy, exactly, but as a reminder of something I'm still working out how to say. There's a version of that morning where I feel humiliated by how I looked, where I feel the sting of that smile, that whispered comment, that attorney adjusting his cufflinks before describing my rented room to a judge. I would be lying if I said that version doesn't exist. But there's another version, the one I return to more often now. In that version, I'm sitting at a table in a courtroom in a suit that cost $14. And I know something that nobody else in that room knows yet. I'm not desperate. I'm not defeated. I'm just waiting for the right moment, and I'm calm enough to wait for it. And when it comes, I don't celebrate it. I just say my name. I said my name. Hess was convicted on 11 counts of wire fraud and tax evasion. He was sentenced to 9 years in federal prison and ordered to pay restitution of approximately $38 million. His attorneys have appealed. I don't follow the appeals process very closely. I have other things to do. My daughter is doing better. She moved back to Fort Worth about a year ago and lives about 20 minutes from us. She comes for dinner most Sundays. She and Lily are rebuilding something together, slowly, carefully, the way you rebuild things that were damaged rather than destroyed. I stay out of it mostly. I make enough food and I set an extra place and I let them find their way. Some Sunday nights I watch the two of them washing dishes together and talking quietly, and I think about what it costs to hold something together through the years when holding on feels unreasonable. I think most things worth having cost more than you expect and take longer than you planned. I retired from field work last spring. My knees made the argument more convincingly than I was willing to. I do some consulting work from home now, reviewing site documentation, flagging issues in survey reports, the kind of desk work I used to consider a step down. I've revised that opinion. It turns out there's something to be said for work that doesn't require you to stand in a ditch in January. I have a good life. I want to say that plainly because I think sometimes these stories end in a way that sounds like victory and looks like the end, and real life doesn't work quite like that. I don't wake up every morning feeling vindicated. Some mornings I wake up at 5 o'clock and lie there thinking about the years I lost and the things I missed and the ways I was quiet when I should have spoken and spoke when I should have been quiet. Those mornings exist and I don't pretend otherwise. But most mornings I hear Lily moving around in the kitchen before I'm up, pouring cereal, feeding the cat we adopted 6 months ago despite my stated position on cats, and I think, this is what I kept. Not a house, not an account balance, not a ruling from a judge. A kid who pours her cereal before dawn and argues with me about whether a cat constitutes a reasonable household expense and leaves her shoes exactly where I'm most likely to trip on them and somehow, still, makes every room feel inhabited in a way rooms didn't used to feel before she was in them. I kept this. Whatever it cost to get here, the rented room, the bleach-spotted suit, the years of silence, the long patience of waiting for something true to surface, whatever it cost, I would pay it again. I told Gerald that once, about a year after the hearing, over coffee. He'd been promoted to a senior position in the federal defender's office by then. He looked at me for a second, then nodded like he understood but didn't have anything to add. He's that kind of person. It's a quality I admire. On the drive home that day, I stopped at the Goodwill on Camp Bowie. Not for anything in particular, I just drove through the lot and sat there for a minute. The same hand-painted sign in the window, the same bins of mismatched dishes through the glass. I thought about the man who bought a gray suit there 2 years ago and drove to a courthouse and sat down at a table and waited. I thought, he did all right. I drove home. Lily had gotten off the school bus and was doing homework at the kitchen table with the cat on the chair next to her, both of them deeply committed to ignoring the rule about cats on furniture. I put my keys on the counter. I started thinking about dinner. It was a Tuesday, an ordinary Tuesday, the best kind.